Hello everyone. A recent TikTok video by one Michelle Keane containing numerous inaccuracies, assumptions, demands and misrepresentations constitutes a shocking attack on both my professional and personal reputation. I do not intend to waste valuable time and attention by repeating them. However, I do need to draw your attention to some principal facts as follows. As many of you will be aware, I had notified the public in a series of videos and public meetings over a number of months issues pertaining to the EU Asylum and Migration Pact. Indeed, I had even furnished my videos to Michelle Keane during her recent election campaign to assist her. Thereafter, she announced publicly that she had taken a case which was listed for hearing on July the 15th. I and my legal team, however, then made an important decision to issue proceedings and seek ex parte injunctive relief when the Dáil vote was adjourned to mid-June. And this we did on Wednesday, June the 19th. And for any of the doubting Thomases out there, the record number is HP 2024-3155. We were granted short service for 2 days later on Friday, June the 21st. As a consequence of an administrative error, a document was not stamped and the matter was not listed on the Friday, and this had nothing to do with me. Notwithstanding, all parties were served and present in court on the 21st and not prejudiced in any way. In addition, and whilst all we wanted was an adjournment to the following Tuesday, the court was not amenable to dealing with the matter at all, as it was simply not listed, and therefore no order was made. Again, contrary to reports on social media where I believe the matter was deliberately misrepresented by some. The court, of course, could have dealt with the matter. Indeed, it is arguable that it should have done so, given the fact that this was a matter of exceptional public importance, but it chose not to do so. Whilst in the process of renewing our application for an imminent date for the hearing, I became aware to my great surprise that Michelle Keane had brought a fresh application before the court on the following Monday, which was the 24th of June, which was then listed for the following day, Tuesday the 25th. As she had already proceedings before the court, it still remains unclear as to how this could even have been permitted under the rules. However, we could not proceed further until her case was dealt with, and as a holding measure, we furnished correspondence to the state and the defendants requesting that they desist from enabling the vote in the Dáil until such time as our case was determined by the court. It is not clear to me why Michelle Keane appears to have taken such bitter offence to my presence at her hearing on the Tuesday. She did, after all, announce it publicly on social media, and the courts are public places, and I attended with many other members of the public. In fact, it would have been absolutely essential that I attend, and arguable that it would have been negligent of me not to do so. In addition, I would have expected Michelle to have been in favour of and encouraging of any other plaintiff who may have had a chance of succeeding where she did not. Surely this is a shared goal for all of us. After all, this is not about Michelle Keane or anyone else, myself included. This is about one of the most important matters ever to have come before the Irish courts. False perceptions lead people to engage in attacks on others when they are not in full possession of the facts. This can only cause division and irreparable harm. As to her application itself, I would refer you to the judgment of the High Court, a link to which is contained in the description box below. Michelle's proceedings were defective in a number of respects, and she sued the wrong parties. She also relied upon hearsay, which the judge stated was not evidence. In his ruling, as you will note in particular at paragraphs 14, 15 and 16, the High Court judge notes that this was a second set of proceedings which is not permissible and potentially an abuse of process. There was no undertaking as to damages, and an injunction cannot be granted in such circumstances. The plaintiff had set out no legal basis for the bringing of her application, and that there were clear deficiencies on the face of the proceedings, which in themselves may well be fatal if the matter were to get to a full hearing. What is more significant, however, is the fact that the State's Counsel did not take any issue with her defective pleadings, which could have been done to have had the case not heard. Instead, the State allowed the case to proceed on what was an historically crucial day of a very important scheduled vote. Yet that same council strenuously objected to my case being dealt with on the previous Friday. It seems that they wanted a judgment of the High Court shortly before the vote. The case conducted by Michelle Keane led to a ruling by the High Court on the day before the vote that Copper fastened an argument that the doctrine of separation of powers would prohibit any intervention by the courts in the Oireachtas, and that indeed was unfortunate. To let you know also, for those who are interested, that my proposed case goes much further than a challenge based on the separation of powers. In addition, the mainstream media never reported on either of Michelle Keane's applications to court, and yet they did on mine the previous week. When Michelle's case was dismissed, the mainstream media reported on the dismissal, but only referred to Michelle by name well into the body of the report. Again, it would seem that this was deliberately misleading to give the impression that it was our case that was dismissed, thus leading to more confusion. Finally, to let you all know that I will update you early next week on developments in my own case, and just to remind everyone that it is so important for everyone to work together to bring about positive change. We can only do this with a cohesive strategy, and it is not about individual personalities. Thank you for listening. Until next time, God bless.